accept this little portion, that is attribution, acknowledgement of receipt, and time and place of dispatch and receipt of the electronic record. Section 11, 12, and 13. So in this whole discussion, we will discuss only three sections, section 11, 12, and 13. And we have to see these section in light of the Indian Contract Act, because they are supporting the communications, and the contract is made through the communication. A want to form a contract with B. Okay, so A will make the proposal, he will communicate to B, then B will accept it, he will communicate to A the acceptance, etc. Similar thing. Now see, the first is about the attribution. The attribution means the act when we, uh, impose on some other persons about an activity, or you can say in the simple word attributes. Okay, when we attributes, generally, suppose there is a communication from A to B. So either this person A send this communication, या A ने B को लेटर लिखा हो, तब हम कहेंगे कि भाई A ने लेटर लिखा हो, और A का कोई ऑथोराइज एजेंट भी तो भेज सकता है B के A के बिहाफ पे. So in that case also, in the law we attribute that this is the communication from A. Or the third situation may be like the company. Company in the law is a recognized person as per the section 9 of the Companies Act. But company does not have mind and the body. It has to act through its natural person, through its employees. And in the law we presume the act done by the these persons is the act of the company, but that has to be duly authorized as per the company. Okay, so this means that when a person make a communication, then actually he's making communication. The second is the situation when any person authorized by person A send the communication. In the law we attribute that it was the communication from A because it was through its authorized agent. Now with the technology, now it became possible that there may be some system operated automatically, and this automatically operated system also make the communication. So what would be the result of that automated system generated communication? Whether we say that that automated generated communication was from the originator or not. Okay, see, there is here there is another important thing, and that is that in the technology term we use three words. One is originator, second is addressee, and third one the intermediary. Now what is the originator? Because throughout section 11, 12, 13 you will find this word originator, intermediary, addressee, and then you want to understand it, पूछोगे कि सर ये होता क्या है. So originator is the word defined here under your definition section. You can find here under 2.1 JAD-A. 2.1 JAD-A. Originator means a person who sent, generate, store, transmit any electronic message or cause any electronic message to be sent. Cause here means by any authorized agent or by through the technology he is doing that. To be sent, generated, stored, or transmitted to any person, but does not include intermediary. But this does not include the intermediary. Okay, I'm not going into this exception because it will be you will better understand when we will discuss intermediary. So originator is the person who actually, or from where the message or the electronic record is generated or is sent or is the transmit. Okay, you send an email, you are the originator. You send an WhatsApp message, you are the originator. And you put transmit, you put the message on the Facebook and publish it, you are the originator. The second is the addressee. Addressee is the person to whom you are you are targeting that your communication will reach. So addressee is that person, and the word addressee has been defined here by this section 2(1)(b), that addressee means a person who is intended by the originator to receive the electronic record. So any person who received the electronic record, or who received the electronic record, does not mean who actually received. It means the originator want to receive the electronic record. So that would be, the addressing. A want to send a message to the B, so he sent this message to that number, and there his intention that this message will be to this person, so he was the addressee. Now someone may ask that, sir, section 2b use the word intended to be received. So suppose A want to send a message to B, but गलती से वो मैसेज सी को चला गया, एंड सी वाज नॉट इंटेंडेड टू रिसीव that electronic record. No, A was not intended that C would receive that electronic message, so that C would not be addressee as per the definition of section 2b. Okay, so originator is the person from where message generate, and addressee is the person to whom this particular electronic record this originator want or intended that he will receive that electronic record. Okay, and in both definition intermediary is excluded. See, here is A, here is B. Okay, and then in between them, to facilitating this whole transmission, there are certain persons, or you can say the company, etc., like the platforms. You send the message from the Facebook to messenger, so first it will receive the messenger team, and then messenger team store on the behalf of originator and send it to the B. Okay, so B, from the B, when it is generated or when it is transmitted or transmitted to the addressee, in that case he is also storing or generating, but because he is intermediary, and in the section in the definition of the originator it has been excluded. So ये पर्पज है वहां पे इंटरमीडियरी का एक्सक्लूड करने का. सिमिलरली ए बी को मैसेज भेजना चाहता है थ्रू द व्हाट्सएप और थ्रू द गूगल जीमेल, तो पहले तो मैसेज जीमेल के वहां पे जाएगी और फिर जीमेल से उसके पर्टिकुलर उस पर्सन को जाएगी. And so Gmail received this thing, and so यहाँ पे Gmail intended नहीं था, that's why it was excluding the intermediary in the definition of the addressee also. Now the third thing is that what is intermediary? Intermediary are all the persons who are making or facilitating. Section 2(1)(w) define that intermediary with respect to any particular record means any person who on behalf of another person receives, store or transmit that record, provide any service with respect to that record, and include telecom service provider, network service provider, internet service provider, web hosting service provider, search engine, online payment sites, online auction site, online marketplace, and the cyber cafe. So this latter part of the intermediary is just explanatory. Okay, otherwise the first part in itself is sufficient, but by way of precaution उन्होंने explain भी कर दिया that on the behalf of the person, when A want to send the message to the B, then first this message will be taken by the intermediary. Okay, and then it will send to the B. Okay, and so when this intermediary is receiving the message, he is receiving on behalf of the another person. Okay, and provide any service with this respect. So when you send any communication through WhatsApp, then the WhatsApp is the intermediary. Internet service provider is the intermediary. That means all those persons who are giving, who are facilitating so that the communication between A to B is the possible. इज नोन एज इंटरमीडियरी। आप साइबर कैफे पे गए, कंप्यूटर आपका नहीं, आप साइबर कैफे पे गए, वहां से आपने मेल किया, जीमेल पे गए और अपने दोस्त को मेल किया। साइबर कैफे का कंप्यूटर यूज किया, साइबर कैफे इज इंटरमीडियरी। ओके, आपने जीमेल यूज किया, वो प्लेटफॉर्म जीमेल इज इंटरमीडियरी। आपने इंटरनेट यूज किया, दैट इज आल्सो इंटरमीडियरी। Okay, so definition in itself is such a wide, it including all things that facilitating the communication, that facilitating the originator to send or to transmit the electronic record to the addressee is known as intermediary. Okay guys, have you got, समझ आ भी रहा है कि आप लोग कुछ बोल नहीं रहे हो?
आ रहा है सर समझ।
Okay.
यस सर,
यस
आ
सर।
रहा समझ।
Now you compare it in the light of contract. Contract में क्या होता है? What is contract? कुछ तुम्हारा पहले का भी पूछ लेता हूं मैं।
An agreement which is enforceable by law.
Yes, very good Nisu, very brilliant student. That an agreement enforceable by law, section 2H. तो agreement क्या होता है? बताओ।
Sir,
Third year में,
it is a
next year.
promise. It is a promise or a set of promise forming consideration for each other.
Very good, very good, very good, very brilliant Akhanda. Section 2 is promises or set of promises forming consideration for each other. Then what is promise? Promise क्या होगी फिर? Yes.
Sir, when the proposer offers to the proposee that he will do or not to do certain things in future in lieu of his consent, then it is called proposal sir.
नहीं, एक promise क्या होगा? Section 2B that when the proposal is accepted it became promise. तो पहले proposal होगा, proposal में आपने मिलाया acceptance, ये बन गई promise, promise में आपने मिलाई consideration, ये मिल गया agreement, agreement में डाला आपने enforceability, ये बन गया contract. ओके, यानी जो मेन कम्युनिकेशन होगी वो प्रपोजर या ऑफरर आप कह सकते हो। सेक्शन 2C तो प्रपोजर कहता है और प्रोमिजोर कहता है और प्रोमिजी। ओके, ऑफरर और ऑफरी भी आप कह सकते हो, प्रपोजर और एक्सेप्टर भी आप कह सकते हो। दिस टर्मिनोलॉजी आल्सो यू कैन यूज। सो आपका ऑफरर और ऑफरी। ओके, यहां पे ऑफरर और ऑफरी कभी चेंज नहीं होते, लेकिन कम्युनिकेशन जब इलेक्ट्रॉनिक मीन्स से होगी तब जब ऑफरर अपना प्रपोजल रखेगा ऑफरी को, तब ये ओरिजिनेटर होगा और ही इंटेंडेड दैट दिस इलेक्ट्रॉनिक रिकॉर्ड शुड बी रिसीव्ड बाय द ऑफरी, अगर स्पेसिफिक ऑफर बना रहा है तो। ओके, ठीक है, तो ही द पर्सन बी विल बी एड्रेसिंग, देन बी एक्सेप्ट करेगा, एक्सेप्ट करके उसको भी तो बताना है वापिस कि आई हैव एक्सेप्टेड, बताना होगा ना, कम्युनिकेशन तो चाहिए ना।
Yes sir, communication of acceptance.
यस, कम्युनिकेशन ऑफ एक्सेप्टेंस चाहिए। नाउ यहां पे तो एक्सेप्ट, कॉन्ट्रैक्ट में तो ये दोनों स्टैटिक टर्म है, बट इन द इलेक्ट्रॉनिक कम्युनिकेशन नाउ दिस ऑफरी, दिस एक्सेप्टर बिकेम द ओरिजिनेटर विद रिस्पेक्ट टू दैट पर्टिकुलर इलेक्ट्रॉनिक रिकॉर्ड। जो एक्सेप्टेंस जो इलेक्ट्रॉनिक रिकॉर्ड है ना, उसके रेफरेंस में यहाँ पे ये ओरिजिनेटर होगा, क्योंकि अब मैसेज यहां से वापिस जा रहा है ऑफरर को, एंड ऑफरर क्या होगा, एड्रेसी। इंटरमीडियरी बीच में सेम रहता है। सो originator and addressee are the interchangeable terms, but the proposer and acceptor are the static term. Now as general we say that we attribute when the person who made the any communication, whether it is offerer or the offeree, offerer made the communication of proposal, offeree made the communication of acceptance. Okay, so either he himself send or his authorized agent, वो तो एजेंसी में हमको एट्रीब्यूट करते हैं। सेक्शन 11 also including the technology part. Yes, please any of you read section 11.
Okay sir. Section 11, Attribution of electronic records.
Hmm.
An electronic record shall be attributed to the originator. A. If it was sent by the originator himself.
Stop. So in this first clause there is no problem. भाई A सेंड कर रहा है किसी इलेक्ट्रॉनिक रिकॉर्ड को, उसकी तरफ से मैसेज जा रहा है कोई, तो यस उसमें एट्रीब्यूट करने में तो कोई दिक्कत है ही नहीं. ठीक है. सेकंड,
By a person who had the authority to act on behalf of the originator in respect of that electronic record.
by an authority, that means the authorized agent, or by any authority you are authorizing to any person, and that authorization should be with respect to that electronic record we have to see. वो आपने अथोराइज कर रहा है और चीज़ों के लिए, लेकिन उस कम्युनिकेशन के लिए आपने अथोराइज नहीं किया है तो वो नहीं होगा. अथोराइज आपका एजेंट है, वो ऐसा नहीं कि वो सारे काम उसके अथॉरिटी से बाहर जाके करता है, नहीं, वट एवर इज इन दैट अथॉरिटी. So we have to see that authority with respect to that electronic record, that whether with respect to that electronic record that is in the question, okay, whether to that this particular person has the authority by the originator or not. So that is also, in the common online transaction, offline transaction medium is also applicable. कंपनी के बिहाफ पे तो हमेशा कोई एम्प्लॉई उसका कॉन्ट्रैक्ट बनाता है हर बार. ठीक है. नाउ द क्लोज सी दैट इज वेरी पर्टिकुलर और पेक्युलर टू द this technological means of the communication. Yes. See.
By an information system programmed by or on behalf of the originator to operate automatically.
Programmed by or on behalf. That means either originator himself has programmed that the automated communication or the message will send, or on his behalf, again as per the clause B, उसका कोई authorized agent ने जो है वो इस तरह का प्रोग्राम किया है, and then it operate automatically. So whatever, suppose you want to make you want to do something, and then OTP is received, and you have to fill that OTP in that particular column, and your phone automatically filling it. That means you made your system to operate automatically. Now you cannot deny that I have not put that communication. I have not put that communication. I have not made that communication, because law is attributing that this automated communication will also attributing to you. This have the legal effect. You cannot deny that it was not done by me, but it sometimes is problematic also. But uh, uh, it has to be seen that if some cases will be there, because there is no exception provided here. Suppose your system misfunctioned, and it automated a wrong communication that you did not intend to be, and in the normal course it would not, but because it malfunctioning or misfunctioning, in that case no exception. If someone put the virus and by that your system became, in that case no exception. But yes, when your system is faulty because of that system, the software company who provided you software, to that company you can, in the compensation you can also club this thing, that because of the malfunctioning of this software I have been attributed to this particular thing also, and for that I have suffered this loss, or I have to pay this much, and this compensation should also be given to the company. Or if some person who entered the virus in your system, to that person also, when there is the question of liability, when we will discuss cyber tort or cyber liability, there is the provision that any person who insert the virus into the system of a person, so the person whose system this virus is inserted and damage is caused, he can claim for compensation. And then section 47 of the IT Act talk about that how much compensation, the quantum of compensation. So there the wrong suffered. So there also you can say that because of this malfunctioning, other party have attributed this thing to me, and by which I have to pay this much. So that thing also to tell them. Otherwise also there is no exception, and still there is no case on this point, so that also we can discuss further. But if we apply the cell presumptions, or maybe I'm telling, I'm not the authority, but as per my opinion, maybe like the section 4 of the Indian Evidence Act that talk about may presume, shall presume, and conclusive proof. So cell attribution is there, and so in that situation maybe rebuttal is possible, rebuttal is possible, but attribution will be there. Okay, should I move further?
Yes, sir.
Yes, sir.
Second, the next is the acknowledgement. Suppose there is a communication between A to B. Okay, आपने एक email लिखा B को, and in that email you have put terms and condition, etc. Okay, and now you want the acknowledgement of receipt also, कि क्या ये communication आपको हो गई, फोन करके पूछते हैं ना, भाई मैसेज भेजा, मिला क्या? Okay, and that section 12 is talking about that acknowledgement of the receipt, and it categorizes that suppose the originator from where the message is originated send a message to the addressee, and addressee got that message, how the originator will come to know that the message has been received by the addressee? For that, suppose the originator want that there must be some acknowledgement of the receipt from the addressee to the originator. In that case, either he has to mention that this is the particular form in which acknowledgement of receipt has to be made. Now when many time when we get the email, before under this email there is 3-4 column that okay, I have received it, etc. That is also in the form of acknowledgement. So the first situation is that acknowledgement is required. Originator ने लिखा है मुझे acknowledgement चाहिए, या जिसका इफेक्ट है उसे acknowledgement चाहिए. और second is situation where originator does not require any acknowledgement of the receipt. The first situation where the originator want the acknowledgement, this can also be classified into two. The first, when the originator has not stipulated that the acknowledgement of the receipt would be in the particular form, it would be covered by section 12 subsection 1. And the second is that the originator has stipulated the electronic record shall be binding only on the receipt of acknowledgement of such electronic record by him. Okay, because some incoherence you will see in that, but we have to interpret so that we can make that there is no conflict. So read section 12 subsection 1. When the originator has not stipulated any form, any particular form of the acknowledgement, उस समय एड्रेसी का क्या चीज एक्नोलेजमेंट को माना जाएगा? ठीक है, प्लीज रीड सेक्शन 12 सबसेक्शन 1.
Where the originator has not stipulated that the acknowledgement of receipt of electronic record to be given in a particular form or by a particular method, an acknowledgement may be given by a any communication by the addressee, automated or otherwise.
तो पहला तरीका तो यह है कि कोई कम्युनिकेशन एड्रेसी से हो, या ऑटोमेटेड कोई चीजें ऑटोमेटेड वहां से चली जाए दैट इट इज रिसीव्ड, या अदरवाइज लाइक हमारे फेसबुक में वो 2 लाइन ब्लू हो जाती हैं, या 2 लाइनें जो हो जाती हैं, दैट मीन दैट इज द एक्नॉलेजमेंट, इजंट इट? otherwise may that is also. Or second is conduct of the addressee. या कंडक्ट जो है एड्रेसी का ऐसा हो दैट सफिशिएंट टू इंडिकेट द ओरिजिनेटर, ही हैज नॉट कम्युनिकेटेड एनीथिंग written, spoken, by whatever means, he have not communicated, not neither automated, not by other thing, but he has did some conduct that indicate the originator that the electronic record has been received. Similar like section 3 है ना, इंडियन कॉन्ट्रैक्ट एक्ट सेक्शन 3, कम्युनिकेशन, तो उसमें कहता है कि कम्युनिकेशन एनी एक्ट दैट इंटेंड टू बी द इफेक्ट ऑफ कम्युनिकेशन. तो सपोज you ask to your friend that I want to purchase your scooty for rupees 20,000, और वो खुश होकर चाबी आपके हाथ में रख दिया. This putting the key on your hand is the effect of communication that he accepted. And section 9 भी इंडियन कॉन्ट्रैक्ट एक्ट सेम कहता है कि द एक्सेप्टेंस communication of acceptance may be in express or implied. When it is in the words spoken, written, then it is express, otherwise it is implied. So similar type of the thing, the conduct of the address is such that intend to indicate that originator that the electronic record has been received. Now read subsection 2.
Where the originator has stipulated that the electronic record shall be binding only on receipt of an acknowledgement of such electronic record by him, then, unless acknowledgement has been so received, the electronic record shall be deemed to have been never sent by the originator.
That mean एज सच अगर इसको डायरेक्ट देखो तो ये थोड़ा बड़ा कॉन्फ्लिक्टिंग होगा तीनों क्लाउज में. दैट फर्स्ट में भी हैज नॉट स्टुपुलेटेड, सेकंड में भी हैज नॉट स्टुपुलेटेड, बट फर्स्ट में हैज नॉट स्टुपुलेटेड द मेथड स्टुपुलेट नहीं हुआ. ये नहीं कह रहा कि ही हैज नॉट स्टुपुलेटेड कि कम्युनिकेशन नहीं होना, एक्नॉलेजमेंट नहीं होना चाहिए. That means he is talking about in the first subsection about the that acknowledgement of the receipt must be there, but the format, specific format has not been provided. The second is the originator has stipulated that the electron record shall not be binding, shall be binding only on the receipt of the acknowledgement, and then that receipt, the acknowledgement of receipt has not been given, so it will have the effect that originator never sent this communication. Okay, so that would be the effect. Now read the third situation, subsection 3.
Where the originator has not stipulated that the electronic record shall be binding only on receipt of such acknowledgement, and the acknowledgement has not been received by the originator within the time specified or agreed, or if no time has been specified or agreed to within a reasonable time, then the originator may give notice to the addressee stating that no acknowledgement has been received by him and specifying a reasonable time by which the acknowledgement must be received by him. And if no acknowledgement is received within the aforesaid time limit, he may, after giving notice to the addressee, treat the electronic record as though it has never been sent.
Yes, thank you, Akhanda, for reading this bulky provision. Here says that when originator has not stipulated that electronic record shall be binding only upon the receipt, ऐसा कुछ भी उसने नहीं लिखा कि भाई अगर तुम एक्नॉलेजमेंट नहीं दोगे तो मैं क्लोज 2 के हिसाब से भाई अगर नहीं दिया तो फिर वो उसका रिजल्ट ये होगा कि इट नेवर बीन सेंड. नीदर इट इज सेइंग दैट और नॉर इट इज देइंग in this way that it must be in particular form, nor it is saying that it must be there. Okay, in that case the addressee has to send the acknowledgement within reasonable time. What is reasonable time is a question of the fact, depend on case to case. Okay, in that case we have to think judicially that maybe in particular case reasonable time is 3 years, in other maybe it is months can be. But if the originator has not received the acknowledgement, in that case the originator again send to the addressee that I have not received this acknowledgement, and you have to send the acknowledgement of the receipt of electronic record within this stipulated time, like 7 days, 2 days, 5 days, and the addressee again failed to give the acknowledgement of the receipt in that stipulated time, पहले stipulate नहीं किया था. So after failing to give the acknowledgement of receipt of electronic record in that stipulated time, then it would be treated that electronic record was never sent. The same thing as in the subsection 2. Okay. Now come to the section 13. It talked about time and place of dispatch and receipt of electronic record.
Sir?
Yes, Deepak.
Sir, is it not depend on the originator's message? Like if somebody says, if you don't want to proceed, just reply. That means if not replying, that means they are accepting it. If it
So
says
that means the conduct of the address is sufficient to indicate.
That's what I'm saying. If in case the message says, if you want to proceed, just acknowledge. So if they are not acknowledging, they don't want to proceed.
Yes. So that
So
would be.
that depends on the kind of a message sent by the originator.
Yes. In the message of the originator itself show that whether he want acknowledgement or he does not want the acknowledgement, etc. And all those, these clause subsections you have to apply it accordingly. Okay.
And sir, one more thing. When you say the intention,
Mm-hmm.
Sorry, just give me a moment, sir.
For time being, I want to take the query of Vikas Deshmukh.
Okay.
Vikas?
Yes, sir. Sir, one thing I just want to clarify. Am I audible, sir?
Yes. Yeah,
Hello?
yeah, completely.
Sir,
Mm-hmm.
sir, yes. Sir, I want to clarify. Suppose a sender who has not stipulated any condition that actually I need acknowledgement to means when the message was sent to the receipt or the receiver or the addressee. So he has not stipulated such condition that actually he need any acknowledgement of that sort. So in that case, that communication has been said to be well received or not?
See, subsection 3 will apply that the originator has not stipulated that the electronic record shall be binding only on the receipt. आप यही तो कह रहे हो कि he has not stipulated that it would be binding only when the receipt of the acknowledgement, and in that case clause 3 subsection 3 will apply. Okay.
One more thing, sir. See,
Yes, yes.
in day-to-day basis, whenever we are sending, today is a era of IT. So we are
generally, these problem will arise only when our relationship is creating some legal obligation, contract type. Social obligation तो वो forcible होती नहीं, तो उसमें इनका ज़्यादा relevance है भी नहीं. But see, the contract is law of the contract is such that we are making contract at at every moment from the beginning of the day to the night. Okay, and so these are the very very important thing. तो वैसे नॉर्मली में नहीं इतना वो होता है, लेकिन कॉन्ट्रैक्ट के टाइम में ये हो सकता है इस तरह की चीजें. ओके.
No, I have my question with reference to one special thing. See, suppose many things, there is a chain of communication, and that is very when you are establishing a claim or a certain thing, that chain of communication should be there in order to establish the event turn of events. So let's suppose
Vikas not audible. Maybe Vikas, you will write this question later on to me. Can anyone hear this, Vikas?
No,
किसी को सुन
sir.
रहा है इसकी बात?
उनकी आवाज नहीं आ रही.
Vikas, your voice is not there, so why we should not disturb. You will you can ask me or you will write. Definitely, I will reply whatever.
Communication
only that case we got. Otherwise, nothing was audible to us. Okay. So Vikas, sorry, we will take your question later on.
Okay, sir, I will ask later stages.
Okay. Now the next is about, I just again want to take your test. Okay. See, suppose there are two persons, A and B. A make a proposal for purchasing the car that B has of rupees for rupees 10 lakh. Okay. He made a communication to B. Both are at the Delhi. B accepted it. Later on, B did not supply the car. B did not deliver the car. That means B breached the contract. A was aggrieved. He came to you कि भाई साहब ऐसे ऐसे हो गया. So what you will advise? To file a suit for compensation. Yes.
Yes, sir. Civil suit, sir.
Yes, sir. Yes.
But question is where? कहाँ फाइल करें?
Sir, in Delhi only.
दिल्ली में तो दिल्ली में कहाँ कहाँ दिल्ली में तो बहुत सारे डिस्ट्रिक्ट कोर्ट हैं.
Sir, if the proposer resides in Rohini, then in Rohini court.
रोहिणी कोर्ट.
और सर वो डिपेंड भी करता है ना कि उनकी कम्युनिकेशन कैसे हुई है, टेलीफोन पे या
नहीं both are at the same place.
Okay,
same place at the Rohini, Delhi. So that's I want to convey. You know that then I will go to the section 13. So account that means we will see the rules applicable there under the Civil Procedure Code 908 section 14 से 24-5 तक जो जाता आगे, लेकिन 14, 15, 16, 17, 18, 19 and 20. 14 अगर सेम दिल्ली सेम जुरिडिक्शन जो है रोहिणी कोर्ट का भी पड़ रहा है, उसके बाद में उसके डिस्ट्रिक्ट कोर्ट का भी हो रहा है, फिर हाई कोर्ट का भी हो रहा है, सुप्रीम कोर्ट का भी हो रहा है, तो लोवेस्ट रंग में जाना है, लोवेस्ट रैंक का जो कोर्ट है यानी रोहिणी कोर्ट. सेक्शन यू नो इफ इट इज अ मैटर ऑफ प्रॉपर्टी देन जहां प्रॉपर्टी सिचुएटेड हो, इस तरह का केस होगा, ये आएगा सेक्शन 20 के अंदर जहां कोज ऑफ एक्शन अराइज हुआ. ओके. कोज ऑफ एक्शन अराइज का मतलब क्या है? जहां प्रपोजल बना हो या जहां एक्सेप्ट हुआ हो. कोज ऑफ एक्शन मींस द राइट प्लस में वोलेशन. You will read it in the CPC. Cause of action, very important. And so in the contract, the cause of action is the moment when the contract is accepted. हमें देखना है कि contract accept कहाँ हुआ है. The place where contract is accepted is the place where cause of action arises, and the place where cause of action arises is the place where suit can be filed. Am I right? And so it's very important to find out. Now Akhanda said that it depends in how the communication made. Very, very good. So physically both are at the Rohini. A make the proposal, B acceptance. वही की वही उसने सुन ली. कुछ दूर में होंगे, 2 मीटर 3 मीटर, अब कोरोना में 3 मीटर दूर रहे होंगे. तो it was the acceptance was at the place where the proposal was made, where the both are the same. So it's not difficult. चाहे आप ये कह लो जहां acceptance हुई, चाहे आप ये कह लो जहां proposal हुआ. The second is about when the two persons are separated and the communication is through letters. Which section will apply? Section 4 of the Indian Contract Act will apply. And in that case, the place of the contract will be the place where the acceptor, A wrote the letter, he is in the Rohini, to the person who is in the Jaipur, and this person B accepted, and then he put that letter into transmission that is out of the control of B, that is place Jaipur. वहां उसने post office पे drop किया. So that is the place where contract is accepted. And so when the communication is through the letters, then the place of the contract, or you can say the contract is concluded where the acceptor accepted. Then comes the another situation that is not covered under the Contract Act. That was the telephonic communication. And in the telephonic communication, the case was Bhagwan Das, Govardhan Das Kedia versus Purushottam Das. It was before the Supreme Court. That Mr. A from the Ahmedabad make a proposal to Mr. B, that is somewhere else, for that khal जिसको बोलते हैं, काकड़े जिसको बोलते हैं, उसके लिए उन्होंने ऑर्डर किया।
ऑयल केक सर, ऑयल केक थे उस
ऑयल
केस में।
केक, ऑयल केक बोल दो अंग्रेजी में, जैगरी बोल दो गुड़ को अंग्रेजी में, बड़ा फैंसी लगता है। ओके, सो अबाउट दैट, एंड दिस कम्युनिकेशन वाज थ्रू द टेलीफोनिक कम्युनिकेशन। तो उन्होंने सप्लाई नहीं किया ऑयल केक, मिस्टर ए ने फाइल कर दिया अहमदाबाद में, मिस्टर बी ने उसको कहा कि नो दिस इज द रॉन्ग प्लेस, कोर्ट ए हैव नो जुरिडिक्शन, contract was concluded at the place of the B. He relied on the section 4 of the Indian Contract Act, and then the Supreme Court said that the law of section 4 will not be applicable. This is instantaneous communication, and so the position is same as the both the person are at the same place. Same place मतलब कौन से place पे? proposal के place पे है, because there is no difference of the between the communication. And so now again the position changed, that it was at the place where the acceptance is received, and acceptance is received but where the proposal is situated, that means at the Ahmedabad. Okay, is it clear?
यस सर।
यहाँ तक तो कोई दिक्कत नहीं। नाउ अब और भी बखेड़ा होने वाला है। The third problem, suppose there are two person, एक हमारा दीपक है, एक हमारा अखंडा है। दीपक lives in चंडीगढ़, स्मार्ट लड़का। अखंडा lives in दिल्ली, इन्फ्लुएंशियल पैसे वाला लड़का। एंड अखंडा एक दिन जा रहा है दिल्ली से अपना जयपुर, तो दीपक अपना चंडीगढ़ से जा रहा है पटियाला, दोनों फोन में मस्त, ट्रेन में, अलग अलग ट्रेनों में। दीपक मेड ए प्रपोजल, भाई तेरी वो बाइक लेनी है पुरानी, you know, he was texting, and while he was at the he was in you know that क्या कहते हैं उसको, यात्रा में है, and अखंडा was also you know accepted. In that case, what place would be considered as the place where the contract is concluded? टेक्नोलॉजी ने ये चीजें बनाई ना ऐसी सिचुएशन दैट वी कैन कम्युनिकेट इवन ड्यूरिंग दिस थिंग, instantaneous communication. What you know this Bhagwan Das Govardhan Das Kedia case is saying, it is applicable when your communication is instantaneous, but your you know that facility is attached to a particular place, that may be you know the telex machine earlier. Okay, अब यहाँ पे ये भी मूविंग है, तो कहाँ पे होना, कहाँ पे होगा या कहाँ पे हो सकता है आपके हिसाब से?
So I think Chandigarh.
और अखंडा?
आई थिंक एट दैट प्लेस वेयर आई हर्ड, मतलब जहाँ पे मैंने एक्सेप्ट किया हो दीपक का प्रपोजल।
अब वो पता नहीं कहाँ किया, और दीपक तो नहीं देख रहा है, कैसे लोकेट करे? पर डिफिकल्ट हो जाएगा ना।
यस सर।
Sir, both the parties wanted.
Patiala,
Sir,
sir.
both the party wanted to accept, file the suit at their place.
नहीं,
So
वो तो रेजिडेंस वाला तो चीज है ही है,
नहीं, मैं वही
बट
कह रहा हूँ
एक
सर।
कोजो फैक्शन भी यहाँ पे होता है ना, सेक्शन 20 में कोजो फैक्शन भी प्लेस होता है, तो उस कोजो फैक्शन में कहाँ माना जाएगा, कहाँ कॉन्ट्रैक्ट कंक्लूड किया माना जाएगा उसके लिए?
When I received the text from Akhanda
And
that he
just
accepted.
to resolve this problem, the section 13 is there. It has two parts. Section 13 has two parts. One with respect to the time, another with respect to the place. So we are discussing the place. Read section 13, subsection 3. It will answer very beautifully. The legal fiction has been created. आपको नहीं प्रूव करना कि आप कहाँ से थे, नाला पार कर रहे थे, नाला पार से 15 थे भाई, एक स्टेट नाले पे इधर पता लगा, दूसरा डिस्ट्रिक्ट हो, नाले के उधर तीसरा डिस्ट्रिक्ट हो, बड़ा डिफिकल्ट हो जाता है। यस, रीड सेक्शन 13 सबसेक्शन 3.
Save as otherwise agreed to between the originator and the addressee, an electronic record is deemed to be dispatched at the place where the originator has his place of business and is deemed to be received at the place where the addressee has his place of business.
Yes. In the both, three things are there. The first is in the both the clauses about with respect to the dispatch. Second is with respect to the receiving of the electronic record. Both have the legal fiction. It's not taking in what is actually. Whenever a legal fiction is created, the word will be used as the deemed to be. That means actually it is not. but law is presuming it. So the proposal made by the Deepak while he was traveling, it would be deemed to be that it was dispatched from the place where he has the business, that means Chandigarh, and accepted at a place where our addressee has the place of business, that is Delhi. ठीक है, अब यहाँ पे क्वेश्चन ये है, सर व्हाट अबाउट द प्लेस ऑफ बिजनेस, हम तो स्टूडेंट, हमारा तो कोई प्लेस ऑफ बिजनेस होता ही नहीं. ओके, सेकंड चीज, समवन आस्क that what about if a person have or a company has 2-3 places of the business, or what about in these situation, and for that there is subsection 5. Yes, please read subsection 5.
For the purpose of this section, A. If the originator or the addressee has more than one place of business, the principal place of business shall be the place of business.
So when a company or a particular person include natural as well as artificial, have different business, then the principal place of the business will be considered as a place of business. Okay, कहां से भेज रहा है उससे कोई मतलब नहीं है. ठीक है, सेकंड बी,
If the originator or the addressee does not have a place of business, his usual place of residence shall be deemed to be the place of business.
प्लेस ऑफ बिजनेस नहीं है उसके पास, स्टूडेंट लाइक यू, सो उसका रेजिडेंस, लाइक दीपक का रेजिडेंस इस प्रॉब्लम में चंडीगढ़ था, अखंड का दिल्ली था, सो देयर प्लेस ऑफ रेजिडेंस शैल बी डीम्ड टू बी, एक्चुअली बिकॉज प्लेस ऑफ बिजनेस तो नहीं है, बट थ्रू दिस लीगल फिक्शन इट इज थ्री. एंड इन केस ऑफ द कंपनी, एक कंपनी का प्लेस ऑफ बिजनेस कहाँ माना जाएगा, प्लेस ऑफ रेजिडेंस कहाँ माना जाएगा. So clause C says that usual place of residence in relation to the body corporate means any company or that have the separate legal personality either under the Companies Act or under special statute, the means the place where it is registered. कहाँ रजिस्टर होती है, जहाँ उसका रजिस्टर्ड ऑफिस रहेगा वही उसी तो एरिया में वो रजिस्टर होगी. सेक्शन 7 नहीं पढ़ा, सेक्शन 7 ऑफ द कंपनीज एक्ट, कहाँ रजिस्टर करवाना है, the place where you want to establish the registered office, in that place you have to find out उस एरिया के रजिस्ट्रार को, कंपनीज एक्ट में जो रजिस्ट्रार है उसको जाके आपको रजिस्ट्रेशन करवाना है. तो आप ये भी कह सकते हो जहाँ रजिस्टर्ड ऑफिस हो. ओके, नाउ इज इट क्लियर? सो इन दिस problem that we have discussed, it was said that the proposal was made from the Chandigarh and it was received at the Delhi, and this was through the instantaneous communication. So now we'll apply the Bhagwan Das Kedia case, that instantaneous communication, and the proposal will be deemed to be concluded where the acceptance is heard, received. Okay, and so it was at the place of Chandigarh. ठीक है, दोनों लॉ अप्लाई करोगे, सेक्शन 13(3)(b) और फिर इंस्टेंटेनियस कम्युनिकेशन का. आर यू गेटिंग माय पॉइंट?
Yes, sir.
या, नाउ कम टू द अबाउट टाइम. टाइम का कैसे हो, टाइम कब माना जाएगा, किस टाइम पे होगा. हो सकता है दोनों बंदे अलग अलग टाइम पे, अलग अलग टाइम जोन में हो, चाइना में बैठा है, दूसरा इंडिया में बैठा है, या इंडिया में ही जो बंदे हैं उनका टाइम किस तरह से माना जाएगा. एंड फॉर दैट इज द फर्स्ट पार्ट ऑफ द सेक्शन 13, दैट इज सेक्शन 13 सबसेक्शन 1 एंड सेक्शन 13 सबसेक्शन 2. यस, अच्छा, सी one thing I forget. In all these clauses you will find save as otherwise agreed. That means it gives the preference to the parties that through the agreement they can make a different rule also. In that case, that according to that rule it will be applied. Okay, but if there is no such agreement with respect to the place of business conclusion or the time of the dispatch and receipt of electronic record, then section 13 will apply. जैसे कि आपका पार्टनरशिप एक्ट में there are many clauses in which there is this thing, save as otherwise agreed between the partners. That means it gives preference to the partner that through the agreement even they can make their independent provision, but if that is not there, then the original provision will apply. Okay, yes, read. Leave this save as otherwise provided, and then the dispatch of an electronic record. Dispatch of an electronic record.
The dispatch of an electronic record occurs when it enters a computer resource outside the control of the originator.
Yes. See how this electronic communication will happen. Suppose A want to communicate to B. Okay, so A will send a message. He will be termed as an originator, and then B, he intended that this electronic record should be received by B. So B is the addressee. Okay, the moment this communication is received into another system, maybe intermediary, या यहाँ तक आ गया हो, out of the control हो, now he cannot get it back. So that is means that is the time when it will be treated that the time of the dispatch. Suppose you send a mail, A send a mail to B, then A after writing the mail send button the this send. Now that is out of control. He is not sure that this particular email is actually received by the B or not. अभी हो सकता है इन ट्रांजिशन में ही हो, अभी इंटरमीडिएरी के थ्रू जा ही रही हो, कुछ टाइम लगता है ना, 1-2 मिनट 1-2 सेकंड, कई ज़्यादा भी हो सकता है. But when it is in a computer that is not in the control of the originator, out the control of the originator is the place where the dispatch time will be treated. Okay. Now subsection 2. Please read subsection 2. Subsection 2. Akhand, 12 subsection 2.
Yes, sir. Save as otherwise agreed between the originator and the addressee. The time of receipt of an electronic record shall be determined as follows. Namely, if the addressee has designated a computer resource for the purpose of receiving electronic records, first, receipt occurs at the time when the electronic record enters the designated computer source.
Second,
if the electronic record is sent to a computer resource of the addressee that is not the designated computer resource, receipt occurs at the time when the electronic record is retrieved by the addressee.
D.
If the addressee has not designated a computer resource along with specified timings, if any, receipt occurs when the electronic record enters the computer resource of the addressee.
Yeah. See, यहाँ पे भी थोड़ा सा inconsistency you can find out, or you will see. So it may be the situation that A sent a message to B. B designated a computer for that receiving that record. आपके पास मोबाइल है, आपको उसमें आ जाएगा, आपके पास लैपटॉप है, उस पर आ जाएगा. और सेकंड सिचुएशन हो सकती है, आप लैपटॉप मोबाइल नहीं है, आप अपनी मेल जैसे पहले लोग खोलते थे 5-5 10-10 दिन के बाद में, यू गो टू द साइबर कैफे एंड देन ओपन योर ईमेल. The situation where you have not designated a computer to receive that electronic record. Okay, so in the first situation, when you designated a computer resource and it appears in your computer, so the point or the time at which it appears, automatically when you receive the mail, the time is written there, so that would be the time of the receipt of the that particular electronic record. If it is through the messenger, there also you will find the time. If it is the WhatsApp, to anything, there would be a time. So it is the time when that electronic record enters into your computer. Okay. What about the situation when you have not the computer? You have not designated any computer for that electronic record. उस केस में टाइम तो हो सकता है वही दिखाए कि 9:54 को मेल आ चुकी थी. ओके, बट आपको तो पता ही नहीं, आपने तो 10 दिन बाद में मेल खोली, तो आपके लिए तो ये सिचुएशन बहुत बुरी हो सकती है ना. आर यू गेटिंग माय पॉइंट? एंड सो
Yes, sir.
clause B is saying that if the electronic record is sent to a computer resource of addressee that is not designated computer resource, then receipt occur at the time when the electronic record is retrieved. When you retrieve, when the addressee retrieve the electronic record, that time would be considered as the time of the receipt. Have you got any question, any query, any doubt? Yes, Vikas.
Sir, if you suppose that in case that I don't have any computer resource or that designated resource, then what would be the place with the receipt? What would the place and time of the receipt?
The time when you will open, when you open that communication and you will retrieve that message, you will retrieve that electronic record. जब उस electronic record को आप retrieve करोगे, देखोगे, समझे? ठीक है, तो वो टाइम होगा. प्लेस आपका होगा जहां पे आपका रेजिडेंस है. अगर बिजनेस है तो बिजनेस है, वो तो चलेगा सेक्शन 13 सबसेक्शन 3 से. ओके, या आपने मेल न्यूयॉर्क में जाते हुए या गोवा के बीच में आपने मेल साइबर कैफे में देखी हो, लेकिन प्लेस आपका वही रहेगा. आर यू गेटिंग, विकास?
Right, sir. Right.
Now, how, why this is important? सेक्शन 4 में भी वहां पे टीचर पढ़ाया होगा कॉन्ट्रैक्ट लॉ में कि जो कम्युनिकेशन का जो गैप होगा ना, उस गैप के बीच में यू कैन रिवोक. आर यू गेटिंग? सो दैट रेवोकेशन इज पॉसिबल, but that revocation must be before the acceptance if it is the proposal. For the revocation of acceptance, it must be before it come into the knowledge of the promisor. तो इस तरह से revocation के लिए ये dispatch of time is very important. Okay, now read clause
What if,
B. Yes,
sir, the fax machine is also considered into this?
fax machine.
Yeah.
In the fax machine, you know, that is treated as instantaneous communication. Because I'm not specified read somewhere, but in the Vakul Sharma you will find a
You are right, sir. You are right. You are right, sir.
list. So there, you know, the telecom, this telex, welex machine, all these are the instantaneous communication. So in the instantaneous communication, तो भगवान दास केडिया वाला केस आ जाएगा. वो तो कह रहा है कि वो तो दोनों सामने ही हैं, कोई डिफरेंस ही नहीं है कम्युनिकेशन के.
How it could be instantaneous, sir? Because fax machine could be, if somebody sends fax, that doesn't mean he is in contact with the person in the continuous manner. They can send fax at any point of time.
You are right. You are right. I'm not saying that it is instantaneous, but I said that I have not find specifically, because computer तो उसे कहोगे आप fax machine को.
Right. It would be computer, yeah.
So अगर computer कहोगे तो then this will apply. Okay. Otherwise, you know, because I found somewhere that that is also treated under the telex machine. Telex भी तो same ही function करती होगी ना.
Yes,
Okay. Now please read B also, because time भी हो गया है. कोई मुझे कहेगा इतना टाइम सर ने वेस्ट कर दिया हमारा. Please read clause B. If the addressee
if the addressee has not designated a computer resource along with specified timings, if any, receipt occurs when the electronic record enters the computer resource of the addressee.
अगर टाइमिंग आपने स्पेसिफाई नहीं की रखी है, टाइमिंग आपकी गलत है उस केस में. ओके, नाउ देयर इज अनदर प्रोविजन दैट इज सेक्शन 13 सबसेक्शन 4. वो वहां पे उन्होंने डाल रखा है. आई एम रीडिंग. द प्रोविजन ऑफ सबसेक्शन 2 शैल अप्लाई notwithstanding that the place where the computer resource is located may be different from the place where the electronic record is deemed to have been received under the subsection 3. Okay, and so this will make you know, it's more clear that suppose there is an email by A to Mr. B and B have not designated a special computer. Then he was on a trip to the Goa में जाके वहां पे साइबर कैफे पे he opened there, and there, you know, at particular time he received. So as per the section 13 subsection he shall be deemed that this communication was at the place where he is residing, he have the place of business. Okay, and so accordingly, the different the computer show resource is located may be different from the place, और उसके जो ये difference का जो चीजें है ना, that would be not applied, but it has to see in light of the subsection 13 uh, section 13 subsection 3. So please go through these three sections, and yes, there is some incoherence you will find in these provisions, but you have to read and you have to best possible way to understand this thing. Still, there may be many type of the the technological device that we either used in the past or now. Uh, that maybe you are finding difficult in that case how the communication will be dealt to it. So for that I'm really, because I went through many books, but I have not find where all the things are covered. In every class, there is something by which we are not finally giving an authority that this is the case, or the authority by which I am saying is perfectly correct. Okay, so guys, with this, today class is over. I have taken your 10 minutes extra, and any question, query, or anything